This is the Week in Sustainability from Workiva Carbon, formerly Sustain Life. It's where our team of experts and practitioners share weekly insights and commentary to keep you up to date about all things sustainability. Hello, and welcome to another episode of the Week in Sustainability. I'm Melissa Zucker, Senior Industry Principal for Carbon here at Workiva. And today we're diving into a significant shift in U.S. climate policy. So, the recent Supreme Court decision to overturn the Chevron Doctrine. We're going to discuss how this impacts federal agencies like the EPA and the SEC and what it means for climate regulations as well as broader government dynamics. So, in this episode, we're going to examine the Supreme Court's recent ruling to overturn the Chevron Doctrine and how this decision fundamentally alters the balance of power across the government entity ecosystem. We'll explore its impact on climate policy, industry regulations, and the future of environmental protection. So, we chatted about this a few weeks back, but let's actually take a step back on some of the history of the Chevron Doctrine, which was established back in 1984. This doctrine has been the cornerstone of federal administrative law that really allows the courts to defer to federal agencies' interpretations of ambiguous statutory provisions as long as those interpretations are reasonable. And this makes sense, right? Because courts aren't domain experts in the things that they're regulating. They're really experts in the letter of the law. And so when that law is unclear, the Chevron Doctrine set the precedent that the government agency regulating that domain would have the authority to interpret the intent of the law. This doctrine initially arose from a case where Chevron had essentially challenged the EPA's interpretation of the Clean Air Act, specifically the notion of emissions generating sources. And in that case, the court sided with the agency, setting a precedent for judicial deference to the agency's expertise. So now let's fast forward, right? In June of this past year, the Supreme Court had upended the longstanding legal principle of the Chevron Doctrine. So in a 6-3 decision along party lines, unsurprisingly, the justices ended the Chevron deference, shifting the balance of power from agencies to the judiciary. So what does this mean? This means that courts now have more authority to question and potentially overturn agency interpretations of laws, even when those agencies have deeper expertise in that domain. So, what are the implications here for agencies? This shift has profound implications for agencies like the EPA and the SEC, which have traditionally relied on the Chevron Doctrine to craft regulations addressing complex issues such as climate change as well as corporate transparency. Now, it's a little known fact, but Congress has never actually ever passed a law specifically restricting greenhouse gas emissions. Historically, the EPA has used the Chevron Doctrine to justify climate regulations, arguing for its broad mandate under laws like the Clean Air Act that give it the authority to regulate greenhouse gas emissions. So without Chevron, these agencies may now face greater challenges in defending their regulatory decisions in court. And that could potentially stall or even reverse progress on key environmental initiatives. So when we think about some of the challenges in this post-Chevron world, now that it's removed, the EPA's ability to enforce climate policies would significantly weaken. So agencies' decisions and policies can be more easily challenged now. With the courts now serving a more prominent role in interpreting the agency authority and regulations, the concern is that further politicized courts could have significant impacts on federal policy that disproportionately reflect party ideals, a direct threat to the balance of power that we seek to have through our three branches of government. When we look now to the SEC, as we know, the SEC is currently embroiled in legal battles over its climate reporting rule, which requires companies to disclose their greenhouse gas emissions as well as climate related risks. So, following the Chevron rollback, the SEC argues that it still does have the authority to mandate these disclosures under its original 1933 Securities Act and 1934 Securities Exchange Act. And those two laws in concert gave the agency broad authority to require corporate disclosures that are deemed important to investors and investment and voting decisions. However, as challengers argue that the SEC has overstepped its authority, we may see this come into play, right? With the Chevron deference now removed, the SEC could find itself in a similar position as the EPA, with a conservative majority Supreme Court limiting their ability to regulate and govern corporate reporting. In this case, corporate reporting that is specific to climate.
Now, the Supreme Court's ruling has significantly altered the dynamics between the three branches of government. With this increased judicial oversight, courts now have more authority to interpret laws that govern agency actions. This shift really moves the power from the agencies with expertise in their domains to the judiciary, which potentially limits their ability to enact and enforce regulations without explicit congressional authorization. Now, this, of course, gets dangerous because as we have a current two-party system and as that system becomes increasingly polarized, the danger here is that the Supreme Court could begin to reflect broader ideological shifts, with the conservative majority taking a more skeptical view on both agency power as well as climate in general. So, as we look ahead, there are some ongoing legal battles that will continue to shape the landscape of U.S. climate policy. Cases challenging the SEC's climate rules and other agency regulations will likely proliferate, potentially leading to significant regulatory shifts. These challenges highlight a dynamic interplay between the judiciary, federal agencies, and Congress in determining the future of environmental and, frankly, broader regulation. The weakening of regulatory oversight could embolden high emission industries to challenge environmental rules, potentially stalling progress on reducing carbon emissions. Industries may feel a little bit less pressure to comply with stringent regulations now that they feel there's an opportunity for those regulations to be rolled back through a litigious process in the courts. So the jury is still out, so to speak, on what this means for the SEC's climate disclosure rule. But I will say, despite these court challenges, what we are seeing in the market is a continued push by enterprise to prepare for climate disclosure. A lot of this is driven by the EU CSRD reporting requirements, and we're seeing a really broad market response to someone get your house in order for true integrated reporting. It does feel like every day we are speaking to more controllers, risk professionals, ESG, compliance teams about how to integrate work streams, establish true governance structures, and enhance data and management for assured integrated reporting. So that's what I have for you today. Thank you for joining the Week at Sustainability, and we will see you next week for more news.
Workiva Carbon provides organizations with an easy-to-use solution to manage the full life cycle of measuring, managing, and reporting carbon emissions. Now integrated into the same platform used to manage the world's most trusted financial and non-financial reporting. Don't forget to like and subscribe to this show on our YouTube channel or your favorite podcast platform. See you next week.